Jim, how does Proposition 3 apply to abortion? And will it return us to Roe?
Again, let's go back and I'm just going to summarize the first two sentences in Section 1. Remember, you have a fundamental right to make a decision and to effectuate that decision with regard to abortion care. And then the second sentence says that you cannot, that right shall not be denied, burdened, or infringed unless there's a compelling state interest. That applies in general to all of the rights, including abortion. But then the third section singles out abortion for special treatment. The third sentence of Section 1. Could you read that?
Yeah, the third sentence of Section 1 reads, "Notwithstanding the above, the state may regulate the provision of abortion care after fetal viability, provided that in no circumstance shall the state prohibit an abortion that, in the professional judgment of an attending healthcare professional, is medically indicated to protect the life or physical or mental health of the pregnant individual."
Okay, so prior to viability, nothing changes. But once there is viability, then the state can regulate the provisions of abortion care. It doesn't say the decision relating to abortion or the decision to effectuate the abortion, but the abortion care it can regulate. But in no circumstance can they prohibit an abortion that is indicated to protect the life, the mental, or the physical health of the mother. So it is treated somewhat differently.
Yeah.
Before viability, I don't think there is any difference.
Okay.
In fact, let me give you an example.
Okay.
Well, let me tell you a little story first.
Okay.
After I got out of college, my first year out of college, Roe versus Wade was passed. One of the big arguments that, oh, this is a good decision was because without it, women may have had a tendency to get what they called back alley abortions. And
Right.
people said in order to avoid that, we
need it. It's a compelling state interest to have something safe and accessible.
Exactly. It's important for that.
It's a medical procedure.
And now, what happens in this case? Let's suppose that there is a woman pregnant before viability. Mm-hmm. Can the state regulate an abortion at all? Can they tell the person who can and cannot do an abortion? Can they tell a person, you can get one, but you have to go to a hospital to get it?
Well, that's dependent, based on this language, on fetal viability.
Only after fetal viability can they do that. In fact, if you look down, there's another section that, and I think it's the last sentence in section maybe 4, where it says that no person can be prosecuted or any adverse action taken against them for assisting or aiding in an abortion. Do you see that language?
So that's in section 3. Okay. It's the second section of section 3.
The second sentence, right?
Yep, excuse me.
Can you read that?
Yeah, so it says, "Nor shall the state penalize, prosecute, or otherwise take adverse action against someone for aiding or assisting a pregnant individual in exercising their right to reproductive freedom with their voluntary consent."
So, if an individual wants to get a backyard abortion, back alley abortion,
Yep.
and
Or backyard, I mean.
wherever, and does the state have any right to regulate that prior to viability? I think it's pretty clear the state doesn't have any.
Well, it's clear. They say the state may regulate the provision of abortion care after fetal viability, but before that, there's nothing stated here that says they can or cannot.
Unless there is a compelling state interest, and of course you could have, the health of the mother could be a concern, but if it's a mother's autonomous decision to get a back alley abortion, then there is no compelling state interest
because it doesn't meet both criteria in Part 4.
Exactly.
It only meets one criteria in Part 4.
Exactly. And a woman, if they so decide, if they make their autonomous choice to have a back alley abortion, there's nothing the state can do to prohibit it, and there's nothing the state can do to prevent the person providing that abortion, or can't take any adverse action against the person providing that abortion.
Okay.
So, but now let's talk about after viability. Now, after viability, they can go ahead and regulate abortion care. I guess that's how you go about doing the abortion and who can do it, whether or not it has to be a licensed physician, whether it could be a midwife, and so forth.
Okay.
And in that, but in that case, there has to be, still the state cannot prevent an abortion if it is medically indicated to protect the physical health or the mental health of the mother. And it's interesting that they use here medically indicated rather than medically necessary. Because
You can quite honestly indicate almost anything when it comes to mental health.
if you look at the dictionary definition, which is we often use in interpreting statutes and constitutions, indicated means to demonstrate or suggest the necessity or advisability of. So it can be interpreted to say that it simply suggests the advisability of
It's
protecting.
advisable to protect your mental health is another way you could say that. Based
Exactly.
on the Merriam-Webster's dictionary definition of indicated.
Exactly.
Okay.
And not only that, but it's for the protection of the mother. Well, what about reduction of risk? Is that to protect the mother? Now, you can go online and you can find a lot of things, a lot of articles and websites that will advance the idea that having an abortion is a lower risk to the mother than going through childbirth or having a cesarean section. So if it's to protect the health of the mother by reducing the risks associated with childbirth or a cesarean section, you could theoretically have an abortion all the way up until delivery.
It's technically,
Because it's-
statistically safer to abort the child than to birth the child.
Exactly. And you could make a similar argument with regard to mental health, particularly if you had a mother who was somewhat fragile in her mental health, that going through this pregnancy would cause great depression and so forth. And then it talks about also, in order to be viable, that the fetus must, there must be a significant likelihood of survival outside of the womb without extraordinary treatment, without extraordinary care. I'm paraphrasing it there. What does it actually say?
Yeah, I was going to say, so in Section 4 of Proposition 3, it says, for the purposes of this section, fetal viability means the point in pregnancy when, in the professional judgment of an attending healthcare professional and based on the particular facts of the case, there is a significant likelihood of the fetus's sustained survival outside the uterus without the application of extraordinary medical measures.
So, what does significant mean? A 10% chance of survival? 50%?
80.
90%? It's not defined.
Okay, fair.
Who makes the decision whether it's significant?
The attending healthcare professional?
Now, okay, I don't mean to pick on healthcare professionals, but in practicing law for 42 years and hiring medical experts and having medical malpractice cases, you can probably find an expert to give you an opinion on almost anything.
Sure.
Now, let me just ask you, if you go to an abortion clinic and you ask them whether or not there is a significant likelihood of sustained survival outside the uterus, which way are they going to lean? Yes, there is a significant likelihood, or no, there isn't. Are they going to use the 10% standard or the 90% standard? What I'm saying is there is a whole lot of flexibility built into this that allows for abortions even after viability. And then the other thing in there, you read that it had to
Extraordinary medical measures.
it had to survive outside the womb without extraordinary medical
with
measures.
application of extraordinary medical measures.
Well, extraordinary simply means going beyond what is usual, regular, and customary.
Right.
So, I mean, usually, okay, they suction the baby's mouth, they put eye drops in them, they dry them off, and so forth. That's probably, and there may be some other things. That's probably the usual, regular, and customary care. What about putting them under an ultraviolet light? Yeah,
Jaundice.
and so forth. Yeah, probably that might be ordinary and customary now. How about putting a child in neonatal intensive care unit? I don't think that's
That's not normal.
That's not normal. So if a
That's
child,
extraordinary.
that would be extraordinary. So if a child was in such a situation that they needed that after childbirth, they wouldn't be viable. Or let's suppose a child had a heart murmur that really needed, or heart defect that needed surgery, and fairly quickly after birth. That's an extraordinary measure, and a child that was born with that would not, a child that had that condition, I don't think would be viable. So my point is, the definition of who makes a decision, what a significant likelihood is, what are extraordinary measures, this leaves it fairly wide open for the professional healthcare provider to make a determination that an abortion is even justified after, late into the pregnancy.
In a hypothetical, if that same standard were applied and you had a medical professional there birthing the child, present at the birth of the child, and we were partially birthed, and the heart murmur was appearing, could we not then
Do a
partial birth abort? Because the child was not fetally viable, so the state can't regulate the restriction of partial birth abortion at that point. So then is it not up to the medical professional in aiding and assisting the pregnant individual in exercising their right to reproductive freedom or abortion, and that the state shall not penalize or prosecute or otherwise take adverse action against that medical professional for performing that partial birth abortion there in the operating room?
I think you're exactly right. That's the way I would read this proposition applied to that hypothetical that you have given us. Let me just say this. The definition of what viability is different than what it is in Wade, Roe versus Wade.
Okay.
The definition of a compelling state interest is different than what it is in Wade. In Roe.
Yep.
In Roe, it allows us to consider the health of the fetus. It's just an entirely different test. It does not, in my opinion, take us back to Roe versus Wade.
It appears the language is broad and frankly unrestricted. It seems that abortions could be completely unregulated. Please read the full language of the constitutional amendment that I've supplied on this website and know what you're voting for this November 8th.